Good morning, ladies and gentlemen. Thank you. I see everybody arrived here safely. We're going to continue with the case. Cross-examination. Mr. Hughes. And Mr. Hughes, I will remind you that you're still correct.
I understand.
And it states Exhibit 66 up there on the overhead. Mr. Hughes, when you dragged Christina Parcell across the floor of the front room where you killed her, did you drag her by her arm or by her ankle?
I don't remember for certain, but I think by the ankle.
That's all the questions I need to ask this, Your Honor.
Any limited redirect?
No redirect, Your Honor.
Mr. Hughes, you can start. Any other witness? Defense going to call any other witnesses?
Your Honor,
And I am aware that you wanted to put additional proffer, but.
yes, not at this time.
Okay. All right. Ladies and gentlemen, I'm going to ask you to go back to your jury room, and I'm going to be taking up a few matters, hopefully very quickly, and we'll be back with you. just be patient and understand there are procedures that have to go in, and I'm sorry that I have to send y'all in and out, okay? All right, anything further?
Nothing further, the defense rests.
Defense rest. Okay, ladies and gentlemen, you can go back to the jury room.
Good afternoon, ladies and gentlemen. This is the moment where myself and the defense have an opportunity to speak to you directly. It's called our closing statement, our closing arguments. All the evidence that you're going to hear in this case, you've already heard it. It's either sitting right here or it's through testimony that you've already heard. And so my goal here is to just talk a little bit about this case with you and sort of explain the state's perspective and how we have proven beyond a reasonable doubt that Zach Hughes did in fact commit the crimes that he's alleged to have committed. And I'm going to go through those crimes a little bit, and we'll talk a little bit about that. And then I'm going to go briefly through the evidence and explain my perspective on those things. I will give you a bit of a caveat that this is a little bit of a unique case in that you rarely have the defendant testifying and admitting to the entire crime during the trial. So in that respect, my closing argument may be a little different or maybe a little abnormal than our normal way we do things, but I'm going to do my best. I first want to thank you for your service. It's been a long 2 weeks. Y'all have been extremely attentive. You've paid attention. You've listened to the judge. And to be frankly, I couldn't ask for a better jury, and I appreciate your service. On behalf of my co-counsel, Mr. Jake Hofreth, Investigator Jared Sparkman, and Master Deputy Blake Wolf, we thank you for your service. Now, I told you in my opening statements that once you see and hear all the testimony in this trial, and I did not know that the defendant was going to testify, you're going to find that Zach Hughes, I don't know if you remember what I said, is a cold-blooded killer. And I submit that the state, and along with the testimony of Zach Hughes, we did in fact prove all of that beyond a reasonable doubt. Zach Hughes is a cold-blooded killer. Zach Hughes is an admitted cold-blooded killer. And keep in mind, he solved John Mello's problems. So the judge is going to instruct you on the law, and just as we're going to abide by his rulings, you must abide by his instructions. Remember I told you he's the referee, calls balls and strikes, and he also tells us what the rules are, what the law is. Y'all took an oath way long ago than you can probably remember back in last week on Monday, a week ago, and you said you would take an oath, you would adhere to his instructions, you would do your duty as jurors, and I have no doubt in my mind that you will absolutely do that. Now, before Zach Hughes admitted to the murder of Christina Parcell, the state called approximately 32 witnesses. We submitted close to 200 exhibits. If you put all this on a hard drive, it's a little over 4 terabytes of information. And all of that taken together, it's a lot of evidence to digest. Now, with the admission of Zach Hughes to a lot of the state's case, the questions you were presented with at the beginning of the case really are answered. Regardless of what he may believed in his head, his actions are what matter in this courtroom. Actions speak louder than words. And boy, do we have a lot of cold, calculated, horrific actions in this case. Now, ladies and gentlemen, you must find the facts based on the evidence in this trial and solely based on the evidence presented at this trial inside this courtroom. And it is undisputed that Zach Hughes planned, he lay and waited, he broke into Christina Parcell's home with a .22 and a knife, some roses. She had just returned home from an interview, from her last interview with Vet Tech. Zach Hughes, a person she had never met, she had never met him, beat her with a gun, brutally stabbed her 35 times, severing her jugular vein and her carotid artery. Now, as we go through the evidence and we look at some of the different things, I'm going to ask you to keep in mind of the charges that you're actually looking at. So the first charge I'm going to explain is the harassment charge. And there's two harassment. There's harassment and there's conspiracy to commit harassment. The only difference is the conspiracy requires two or more people joining in to commit the harassment. So harassment is just a pattern of intentional, substantial, and unreasonable intrusion into the private life of a targeted person that serves no legitimate purpose and cause that person and would cause a reasonable person in his position to suffer mental or emotional distress. That's related to all those photos and those documents that you saw mailed out. I think there's 7 envelopes full of photos and other documents. You heard testimony about what was in those. Some of them are in evidence, some were just described, because those were pictures of Christina Parcell without any clothes on. So we didn't introduce those so as not to embarrass her or her family. Burglary first. A person is guilty of burglary first if he enters a dwelling without consent and with the intent to commit a crime. And I remind you, the judge is going to tell you the law is, what it is. I'm just trying to give you an outline so you can keep that in mind as we're going through this evidence. And they enter without consent and they're armed with a deadly weapon or cause physical injury. Well, those things all already appeared in this case. Zach Hughes went in under a ruse of roses according to his own testimony, but he went in directly with the intent to commit harm and he had weapons on him. And then you've got murder. You also have possession of the weapon during the commission of a violent crime. That is, if you used a weapon and you murder somebody, that is the possession of the weapon during that commission of a violent crime. But you have murder, which is the killing of any person with malice aforethought. Malice aforethought. And you're going to hear those words a lot in the judge's instructions. But malice is ill will towards another person, the intentional doing of a wrong act with the intent to inflict injury. And I think I said early on, ladies and gentlemen, it was a depraved heart, an angry heart, with the intent to harm somebody. And there's also express malice, meaning it's expressed, it's right there in front of you. And it's shown when there are words of hatred or when someone prepares to do the act. They prepare to go in there. It's called premeditation, is what you'll hear the judge charge you. Premeditation is preparing to go and harm somebody, like lying in wait, like buying weapons beforehand, by concealing your identity going in there. Those kinds of things are premeditation, things that you do in preparation of the violent act. And if you find those things, and you find the state proved those beyond a reasonable doubt, then you can find the defendant guilty. So before we get in, let's start with a little background now. You know the players, you know everybody involved in here, you know the victim. You've heard a lot about the victim, Christina Parcell. You've heard a lot about John Mello. You've heard a lot about Zach Hughes. And you've heard a lot about Christina Parcell and John Mello's daughter. So the background, and we're talking the time frame from 2020, October 2020-ish, to October 13th, 2021. So we're roughly a time span of 1 year. And what happens throughout that year that leads up to the murder of Christina Parcell? Zach Hughes never talked to Christina Parcell. He didn't know Christina Parcell. He never met Christina Parcell. And everything he knew about Christina Parcell, even according to his own testimony, was told to him by John Mello or shown to him in certain evidence. John Mello was in a nasty custody battle with Christina Parcell. We all know that. He was on his 4th round of custody disputes with Christina Parcell. Keep in mind, and according to the guardian ad litem, the prior 3 were just as nasty, but they had always been settled where John Mello would have significant custody of their daughter. But in April of 2021, that changed. The tide changed for John Mello because he took Aida out of the country in violation of that order, according to the Italian courts. And he took her to Italy. And Christina Parcell didn't even know about that until she saw a social media post where she realizes, my daughter's out of the country, I can't see or talk to her, and she's with her father. thus the continuation of this nasty child custody dispute. And then from October to April, Aida was living in Italy with little or no contact with Christina. So what did Christina do? She did what any mother would do, is she tried to get the return of her daughter. So she went through this process, and it was explained by Christina's sister, Tina Parcell, as well as the guardian ad litem, Vanessa Cormelo. She filed under what's called the Hague Convention, and she asked to have her daughter returned to her. She actually flew to Italy twice to have these hearings in Italy. And she was successful. She won that particular battle in this myriad of battles of child custody that had been going on between these two individuals. And so in April of 2021, that really set off John Mello. He was unhappy. And we know the things, and we're going to talk about the things that he did starting that day, through the WhatsApps, through the harassment letters, everything else, to solve that custody dispute problem. And that's where this case really, really began. That is when things turned, not in favor of Christina Parcell. She lost her life as a result. So, what is the relationship between Zach Hughes and John Mello? All right, so where did they all come into this mass of characters? Well, according to Zach, he met John on the streets of Greenville about August of 2020, and he was with Aida, and Zach played a very likable classical music piece that John Mello and Aida liked. And that's how they met. So they met that one time. And that was one of the few times that Zach Hughes actually met Aida Mello. And he talked about, they went on about 4 or 5, maybe 6 occasions where they were hanging out. They got some tacos one night. They saw a museum. But Aida Mello didn't know Zach Hughes. She didn't know who he was. She's a 9-year-old little girl who heard him play a piano piece, who's a friend of her dad's. And that's all the time they ever spent together. That's it. In August until October, John Mello left for Italy. And with him went Aida. So Zach Hughes never spent any more time with Aida, what little time he did during that small time, ever, never again. Now, he may have seen her on a FaceTime while he's talking to her dad, or he may have seen her or seen videos of that, which he testified to. But Zach acted on this stand as if he could see into her soul. He could see into her eyes. He knew how she was feeling. He could tell that she gained weight and why she gained weight at a certain particular time in her life, in her adolescent life. He is drawing those conclusions on a little bit of information and nothing but whatever John Mello is feeding him. So, what's their first thing? Aida's back with her mother. She, in May, begins living at Canebrake with her aunt, Tina Parcell, and that's where they're living there. John Mello's in Italy, and Zach Hughes and John Mello decide, well, you know what we're going to do? Let's embarrass Christina Parcell. Let's make her life look bad. Let's make her look like a prostitute. That'll help me get custody of her. That'll help me with the guardian ad litem. And so John Mello, according to Bevel, Detective Bevel, who testified, had photos, and according to the evidence right here, he had photos of Christina Parcell. And those photos were taken when she was much younger. And those photos are taken between two consensual adults engaging in what acts that two consensual adults can do. And that's it. And then he took those photos and he used them as a weapon. And he tried to make her look like a prostitute. Because that's what John Mello continually told Zach Hughes, according to his own testimony, Alex Field's affidavit. Let's make her look like a prostitute and let's send them around to a neighborhood. Well, they sent them to a neighborhood where Brad Post lived. They didn't even send him to Canebrake. And we know this because in these WhatsApps, they talk about it specifically. They talk about, may I present to you my daughter's mother, Christina, Caroline Warren, escort. And we know there's a bunch of attachments that we can't see because Zach Hughes deleted these on October 13th. And when we retrieve them from WhatsApp, they're deleted. So you have to see us, Investigator Sparkman, manipulating these WhatsApps. And then they sent them that way, and then Zach Hughes receives them. He gets them, and he sees an email that was sent to him as well. This email is very important. And he prepares all these packages to Brad Post, to Mr. Bradley Post. These are all his P.O. Box. Brad Post. Cigar bar, where Brad Post hangs out. Misspells Mr. Post one time in the WhatsApps. Misspells it here, P-O-A-S-T, which is why we know it. But Zach Hughes admitted it. But this email here purports to come from Mullen Investigations. Mullen Investigations at protonmail.com. And it's cut out. And you've got this photo of Christina Parcell, and you've got another photo of Christina Parcell back there, which is the same ones that are in here. But there's no URL with Bella Dongion right here. And this is the escort site, and it says Caroline Warren. She became a member, Caroline Warren, in 2009. Well, this is 2021. And apparently this Mullen Investigations on May 16th found these photos attached to this website, except the photos don't have anything attached to the website. It's just a square of an escort site of Caroline Warren. Well, I don't know who that is. I know this. I know Caroline Warren. I know Mello Investigations, John Mello. Vanessa Carmelo testified to it. She received emails from Mullen Investigations, and she received lots of emails from people purporting to be John Mello. So Zach Hughes went to the trouble of preparing all these envelopes, manipulating all the items, the photos, the escort, and putting it together, and he wanted to make sure we knew it was her, and so we would add a cover letter. You can see the cover letter that he would do. He had to add a cover letter to make sure you knew exactly who that was, that it was Christina Parcell that was engaging in prostitution. And he sent them out to shame her, to make fun of her. There's WhatsApps in there saying, we're going to ruin her day. And Zach Hughes did it the same way he committed this murder. He used his bike, he avoided cameras, tried to find a location, and he didn't know that we could track his phone. And so we know he was in Greenville when he mailed those in June and July, and he was in Tennessee when the other two were mailed. So we know he did all that. But the big point of the harassment is not that that's bad to do somebody. It's really what Tina Parcell referred to as revenge porn. South Carolina does not have a statute for revenge porn. We have harassment. And that's exactly what that is. But he's really doing it, one, to make her look bad, to make her look like a prostitute. But he's also trying to do it to gain a strategic advantage in this custody battle. And it doesn't work. He even sends one to the guardian ad litem. What does the guardian ad litem do? She investigates everything. But Brad Post put a lot of work in. Zach Hughes put a lot of work into that. It's a lot of work finding all those envelopes. To somebody he doesn't even know, he's never met, never talked to. Now, John Mello, I would say he's pretty much a liar. He dated Christina back in 05 and 06 and had their daughter in 2012, and of course this custody battle. And if you want to look about the character and who John Mello is, I refer you back to Vanessa Cormelo's testimony. She testified that John Mello would do horrific things in relation to this custody battle. To her, to a lawyer who's representing a little girl as a guardian ad litem who's practicing law for 26 years, he would accuse her of horrific things, according to her. He would accuse her of trafficking children in Spartanburg. He would post things on social media ridiculing her. And that's how John Mello operated. That's how he operated. He used deceit by using fake emails. He used threats to try to get what he wanted. Mullen investigation. He sent those to Vanessa Carmelo. He sent an email pertaining to be a lawyer named Sophia Carlucci, according to Vanessa Carmelo. And she knew it was John Mello writing it because she's read so many emails from him, they matched up. So he's trying to gain a strategic advantage. John Mello and Zach Hughes were trying to harm Christina because John Mello had a custody problem. And the only way to solve it was murder. So Zach visits John for 3 weeks in June in Italy. So he met him for 5 times between August and October of 2020. They're having lots of conversations on the WhatsApp, and he's in 3 weeks in June in Italy. And it was a pretty important moment when Zach Hughes said, John Mello offered me $5,000 to kill Christina Parcell. John Mello offered me $10,000 to kill Christina Parcell. Now, of course, Zach said he wouldn't take that money. He would just do it for free. Because killing Christina Parcell is the right thing to do. So I submit that's when the plot to murder Christina Parcell began. That's kind of when this evolved. And I think they started with the photos, which were in June and July, but that wasn't going to carry any weight with anything. Interesting that a struggling pianist turned down $10,000. Do it for free. Especially of a person he's never met on behalf of a little girl he barely knows. Now, much of what Zach Hughes said, I believe, on that stand was true. I think a lot of it was a bunch of self-serving, narcissistic junk. Zach Hughes is trying to portray himself on that stand as a hero instead of the cold-blooded killer that he is. Ladies and gentlemen, we judge the defendant by their actions, not by their excuses or their words. Actions speak much louder than any self-serving lies from a sadistic, pathological killer like Zach Hughes. He murdered Christina Parcell, mother to Aida, sister to Tina Parcell, and daughter to Erica and Tim Parcell. Now, I've talked a lot about Vanessa Carmelo because she's a key witness, because that is the dispute that we're having, the custody battle. And she's in charge of making recommendations about who should get custody. Her job is to investigate the custodians. She stated that she investigated every allegation which were at Christina, which was involved in prostitution and drugs. She stated she would investigate every allegation, hire private investigators, put trackers on cars, meet with potential custodians, have home visits, and talk with the child constantly. So she's doing everything that she can possibly do. She even had allegations like Alex Fields. There's an affidavit that the defense submitted on Alex Fields where he says that he was propositioned by Christina Parcell for sex and offered to sell him drugs. And he put in an affidavit. This was after John Mello put on Craigslist, "You have any information about Christina Parcell that I know about? I'd like to know anything about." Who responds to a Craigslist ad about somebody and then sets an example of what they did at a bar? And for what purpose? Maybe it's true. Maybe it's not true. I have no idea. That's what Alex Field says. Really doesn't matter. While the defense wants to impugn the integrity of Christina Parcell as a justification for committing murder, so be it. If doing bad things means anyone can break into my house and stab me 35 times without retribution, then two things will happen. There'll be a lot of people stabbed to death, and I'll be out of a job, because all we'll have is vigilante justice in our system. But again, these are allegations that John Mello is making. He's looking for any dirt on Christina Parcell. Again, these are all allegations. Well, let's come to October. Vanessa Cormelo was getting close to making her decision. Who's going to get custody? Her investigation revealed that before Christina's murder, she would write a favorable report for Christina Parcell and a bad one. That's what Vanessa Cormelo said. In addition, it was almost 6 months since Aida had come home, and that's important. 6 months. Someone can file to terminate the parental rights of another. We were about to be 6 months. Zach Hughes said October was the time that he felt it was the time to kill her. Just felt it in his heart and his mind. And he tried on the 12th, did it on the 13th. That is important because it was getting close. John Mello's getting a bad report, and things aren't going to go his way, so he's got a problem. Now, if Christina Parcell is no longer around, he's the last man standing. He's going to get custody. So, Zach admittedly decides to murder Christina Parcell. That was his intent. He bought a gun and a knife about a month before. It was weighing on his soul. His custody dispute's not going well. And so he entered into a lot of planning going into this murder. A ton of planning. And the state presented all of this evidence to you before he testified. But we know that Zach Hughes on the 12th was up at the Mountain House because his phone showed that he was up there. And while up there, he had his truck. And we know he put his bike in the back of the truck. And we know he parked it somewhere. And we know that he decided to park somewhere near Canebrake and ride his bike in there. And we didn't know, but we know that he knew the schedule of Christina Parcell that day because he said John Mello told him. So he gets in his truck, and I would submit he arrives around 7:42-ish to somewhere wherever he parked. We never learned exactly where he parked near Canebrake, but we know he parked somewhere there, and he rode his bike. Because at 7:42, we know from his phone that he plugs it in and unlocks it. And that's the last activity on his phone at that time. So he parks, maybe he plans, he thinks, and he gets on his bike and he drives in. And we know he drives in because he passes Donna Gorman's house. And Donna Gorman was an early witness from the state. And she did an identification of Zach Hughes from that witness stand. State was not expecting that. We had never shown her a photo lineup. We'd shown her a photo of the bike, of Zach on the bike from the ring cameras. But she had never seen Zach in person. And so we just left it. Now, we did wait until about 3 years after the murder before Donna Gorman told us that information. That is true. Riley Stokes talked to her that day, and he didn't have a copy of it. Master Deputy Wolf talked to her on the 19th, and he didn't show her a copy of the person on the bike. And so there was so much chaos going on, so many officers moving in so many directions, trying to find the evidence to solve this murder. It was just overlooked. And so when we went and talked to her, this was her testimony. And that's what we presented to this jury. She was right. She was right. The DNA proved it. Zach Hughes proved it. So Donna Gorman sees him, and she says this around 8:15-ish when he goes by. And then he goes to Christina Parcell's house. And my opinion is that he went and he hid under the bottom of the house. His testimony was different. He says different. He says that he got there and went straight in, dropped his bike, and went to the front door. We have a difference. Maybe he's telling the truth. Maybe I'm wrong. At the end of the day, it doesn't really matter. But I submit that he went and he waited. He had an hour to wait. Of course, he had an hour drive from the Mountain House all the way to Canebrake. You know what he could have done? He could have turned around. He could have done anything he wanted. He could have gone to the QT. He could have changed his mind. Had many opportunities to do that. He was committed. And so he went and he lied and he waited. And he waited for a time because he knew her schedule and he knew her car. He knew her address. That's in evidence. And he went and he decided to walk in the front door with roses as a ruse, according to his testimony, with a gun and a knife and a backpack, paint thinner so he could clean up afterwards, and he kills her. So let's see the moments before Christina Parcell is murdered. Zach Hughes, dressed as he said he was, gray sweatshirt, backpack, black pants, walks directly into that house. I can't see if he's carrying flowers. I know he had flowers on him. And he walks in and he surprises Christina Parcell. Points a gun at her and hits her in the head with the gun. And then he stabs, and he begins to stab, and he begins to slash, and he begins to slash, and he begins to stab, and slash. Now think of the force needed to stab someone in the chest, stabbed him in the back, all over the head. And finally, and through all the fighting, and the stabbing, and the pushing, while Christina is fighting for her life, he finds the vulnerable spots, stabs her in the jugular and the carotid artery, causing her to bleed out. With blunt force trauma to the head, she has to be on the ground. Blood is everywhere, pulling around her dropped phone and the couch. But that's not enough. He drags her through her own blood to cover up the crime as he closes the curtains and locks the front door so he's not detected as droplets of blood fall from his blood-soaked clothes. She remains laying on that floor in her own blood with nothing but her blood-soaked scrubs and her wedding band that Brad Post gave her. But his sadistic actions are not over. I submit, ladies and gentlemen, those rose petals had a dual purpose. He may have used them as a ruse to get in and get inside the house so he could surprise Christina and gain that strategic advantage to murder her. But he also sprinkled them around. He sprinkled them around the house, on her purse, around, as some sort of sadistic, artistic sign that he thought was necessary. And then he had to keep in line with the allegations: prostitution and drugs. Put a bag of cocaine under a couch or in a chair right down from her body. Killing her wasn't enough. Shaming her was the goal too. This was not to save Aida. This was to help John Mello win his custody case. He never told us about the drugs either. Never mentioned those. So then the cover-up. So then, after you effectuate the crime, you commit it, then you got to clean up. You got to cover up. So, he first had to cover up the scene. He had to worry about that DNA under her fingers. That DNA is key to this case. He had to wipe her fingers down with that paint thinner. He did not want to get caught. Pre-planned, and then really good exit strategy, cover up. Then he went back to the mountain house. Of course, we know he's there because his phone puts him there around 1:17. He connects to the Wind Wi-Fi. The Winds have a mountain house. He has access to it. Remember, it's real remote. I think Master Deputy Wolf said, it's so remote you could walk around naked. Nobody would see you. Perfect place to clean up a crime scene like that. Can you imagine how soaked in blood his clothes were? Can you imagine how soaked in blood his car was? Can you imagine how soaked in blood his bike was? And he did. And he admitted it. Burned his clothes, ditched the knife and the gun in some pond, cleaned up everything, and he went back to Tyndall about his daily life. And that's what he said. Now, I've mentioned Zach Hughes' testimony a lot. And I'm sorry that you had the unfortunate privilege of hearing the specific testimony of the killing of Christina Parcell by a cold-blooded, cold stone-faced killer trying to portray himself as a hero instead of the cold-blooded, calculating killer that he actually is. Only a person with a severely demented sense of heroism, with a heart that is cold as ice, can portray that. The absurdity of many of his words and I'll reference a couple. I wanted to make her death quick and painless. This is what he said. When I was listening to that, it was hard for me to comprehend that someone is actually saying that at their trial to a jury? Do we say thank you? I appreciate it. Thank you for taking my pain into consideration as you murder me? What does that even mean? Well, I ask you this. Was it quick and painless when he hit her in the head with a gun? Was it quick and painless when he stabbed her the first time? Was it quick and painless when he stabbed her the second time? How about the 5th? The 10th? Maybe the 20th? He was being considerate. Maybe the 30th? How about the final 35th blow? And then, of course, I asked him one question. How'd you drag her body across the room? And he said, I don't really recall, but I think it was by her ankles. And he looked me in the eyes in a stone-cold-faced way. Told me the answer. Like he was proud of it. He said, I do not want anyone else to be involved. I waited till everyone was gone. Thanks. Appreciate that. Talking like he's doing us a favor. I wonder what would happen if a neighbor did come over. I wonder what would happen if Brad Post had showed up. I wonder what would happen if Tina Parcell had showed up. Would it be a double homicide? So we could escape and escape detection? And of course, he was so calculated, he got her schedule that day from John Mello. And then he said, I didn't want to get caught because they would connect me to John Mello. Oh, okay. So if you didn't get caught, you've solved the custody problem. But if I did get caught, then I didn't solve the custody problem because then they would connect me to John Mello and he wouldn't get custody. Then he comes in here, testifies, connects John Mello. Doesn't make any sense. Now, he talked a good bit about his background. My understanding, he's a fantastic pianist, highly trained. But he went through his resume with an ego, letting you all know how great he really was. Military service. Playing these really difficult sonatas by Beethoven. I'm going to play all 16, never been done. But he described his sister Grace in great detail as well, for some reason. He said she was a horrific person when confronted with irrefutable evidence. She would go cold, stone-faced. She would manipulate and recruit others to do a terrible deed. If you trust Grace, you're only going to get hurt again. She was a vampire and would suck the blood right out of you. Maybe he's describing himself. He said, I feel pity for her. He felt pity for Christina Parcell. How was that even possible of a human being? His heart is so mean, so depraved, that he viewed someone he'd never met and discussed the specific details of killing her treating her like she was an elderly dog being sent to the vet to be euthanized. It doesn't get any meaner than that. Christina Parcell didn't have to die. Zach Hughes had a million opportunities to not do this. And if he did it to save Aida, there's a million ways to handle that. Vigilante justice is not allowed in this state. Vigilante justice isn't allowed anywhere. Regardless of what Zach Hughes had in his mind or what he thinks he had into his heart, he's lying to himself. Because all he had was hate and meanness, coldness. He brutally murdered Christina Parcell. So, ladies and gentlemen, it's been a long 2 weeks. I thank you for your service, and I thank you for listening to me. The evidence is absolutely overwhelming. I'm going to ask you to go back there and deliberate. I'm going to ask you to find Zach Hughes guilty of harassment, of burglary, of possession of a weapon during the commission of a violent crime, and murder. Thank you.
Mr. Moore.
May it please the court. Let me get a little bit of water. Okay. I want to start with something that Mr. Wilkins said towards the beginning of his comments to you. He said, Zach Hughes solved John Mello's problems. Yesterday, Zach Hughes told you he solved Aida Mello's problems. That's what he told you yesterday. Ladies and gentlemen, you got to watch the state. You got to watch the evidence. Zach Hughes yesterday came in here and told you under oath that he killed Christina Parcell on October the 13th, 2021. He told you that. But contrary to what Mr. Wilkins just told you, killing somebody in and of itself is not a crime. Mr. Wilkins told you that he confessed to committing the crime. That is not the case. Yesterday, Zach Hughes told you that he killed Christina Parcell, but in doing that, he did not tell you or confess to any crime. And let me be clear, and let me tell you why I say that. Every crime, and the judge is going to tell you this in the instructions, every crime has two parts in general terms. The actus reus, which is the action, and the mens rea, which is what's in your mind, the intent, that the state has to prove beyond a reasonable doubt. So it's very important that you understand this from the get-go. He did not confess to a crime yesterday. He confessed to killing Christina Parcell. But that in and of itself does not make him guilty of murder. That's very important. Okay? The first part of, or Mr. Wilkins had talked about how this case is unique. It is unique. And one of the unique parts about this case is that first part that I talked about, the actus reus, the action that's involved, there's very little dispute, if any. Zach admitted that he killed Christina Parcell, right? Where the dispute is where the heart of this case is the evidence as to what was in Zach's heart, what was in Zach's mind, that the state must prove to you beyond a reasonable doubt. It must be evidence that leaves you firmly convinced. It must be evidence that would cause you not to hesitate to act. Right? That's what they have to do. So the heart of this whole case, Mr. Wilkins can talk about the blood, he can talk about the scene, he can talk about all these things. But the heart of this case is the intent, is the mens rea. What have they proven about Zach's intent? All right? Now, let's talk more about what the judge is going to charge on the law and what they have to prove about intent, about the mental side of this. All right? Zach has been charged with murder. The state must prove beyond a reasonable doubt malice. That is the intent, the knowledge, the mental part of murder. The state must also prove burglary in the first degree, that when he entered that home, he intended to commit a crime. In this case, murder. He intended to commit the crime, which means there was a crime he committed. For harassment, the state must prove that he sent those mailers, which he admitted to doing, he sent those mailers without a legitimate purpose. And for the conspiracy, the state must prove that he formed an agreement to do something illegal. That is the mental component to this. And again, that's the heart of the case. And Mr. Wilkins in his opening statement said, we have to prove the state beyond a reasonable doubt an angry heart, that Zach was mad. That's where this case, that's where the heart of this case is. What was Zach thinking? What has the state been able to prove beyond a reasonable doubt about what was in his heart and what was in his mind? Now, you're going to hear, the judge is going to talk to you about different types of evidence you can consider. He's going to talk to you about circumstantial evidence, which is evidence that an arrangement of facts, when put together, that lead to other facts or conclusions. That's circumstantial evidence. Judge is also going to tell you about direct evidence. Direct evidence is evidence that comes from people who perceived what happened, who with their senses derive knowledge about what happened. All right? That is direct evidence. The state has the burden of proof on the mental element, and the state is going to use circumstantial evidence. That's what they're going to use. We have no burden of proof whatsoever. We entered and are going to use both direct evidence and circumstantial evidence to explain what Zach's state of mind was on October the 13th, 2021. Now, what is the state going to do to try to prove what was in here? To try to establish the burden of the mental side. Again, it's more than just the acts. That's critically important. But what's the state going to use to prove the mental component to this? They're going to use the acts, and they're going to say, they're going to use the stab wounds, the photos. They're going to use all the actions that Zach testified to yesterday. That in and of itself is not a crime. And Mr. Wilkins, he talks about stab, and I wrote this down, stab, 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 slash. Right? Got to watch. Got to be careful, right? This is a tragic case. Bottom line, someone died. The last thing I ever want to do is minimize the tragedy in this case. Not going to do it, all right? But when we come to talk to you about what happened, you have to have faith that what we are saying is balanced. Think about what Zach testified to and what Claire Rose testified to about Christina Parcell and what happened that day. All right? Stab, 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 slash, slash, slash. Claire Rose testified Christina Parcell was 163 pounds. Zach testified that he was 160 pounds. Claire Rose testified that there were, of the 35 wounds, the vast majority were incised wounds. superficial wounds, wounds that would have been consistent with a struggle. Zach told you that when he went inside, there was a struggle. He told you that they fell to the floor. He told you that when he got inside, his body would not do what he was telling it to do because he didn't want to do it. He did not want to have to do it. So let's talk about the circumstantial evidence that the state has offered as evidence to try to get you to understand what was in Zach's mind. The state talks about, in determining how much weight to give to their representations about their conclusions on the circumstantial evidence, just think about this. Donna Gorman testified that 3 years after this happened, having never been shown a photo lineup, with Zach's face all over the television and the internet, that she says that she saw Zach. Now, here's what is most troublesome about this whole thing. She testified that she saw Zach at 8:15. That's what she testified to. She testified she saw Zach through 2 trees in her house, that he was wearing a hoodie, no evidence other than what she said about a hoodie. In fact, Zach said that he was wearing a hat or a smaller hat. There is no way that she could have seen Zach Hughes at 8:15, because by the state's own evidence, with the ring cameras, with investigator Sparkman, the state's own evidence, Zach didn't even get there until after 9 o'clock. So when he says, Donna Gorman, she saw him, it's impossible that she saw him the way she said, because she said 8:15. By their own admission, by their own evidence, Zach didn't even get there until after 9 o'clock. Think about that. In determining how much weight to give to their spin on the circumstantial evidence, think about investigator Sparkman, all right? Called him as a witness and showed him reams of WhatsApp messages. These messages were garbled, but he had a unique skill. I don't know if he went to WhatsApp school, but he spoke fluent WhatsApp, right? And he was asked to decode all of these messages for you as though you couldn't have done it yourself. But what's the most interesting thing about what he said in the WhatsApp messages, there was one message that he was not able to decode, coincidentally. The message that had the words Aida and doomed. That was the only message he could not uncode for some reason. Think about that. In trying to determine how much weight to assign to the state's conclusions or their spin on the evidence, think about Vanessa Cormello and what she testified to. Mr. Wilkins talked about how she was doing everything she could during this period to uncover it. Really interesting, and the judge is going to tell you this. You can determine or decide how much weight to give to testimony. You can give it a lot of weight, you can give it a little weight, you can give it no weight. I want you to think about how much weight to assign to the state's conclusions and that testimony, because I want to take you to one specific exchange between Jake Hofferth and Vanessa Cormello. Jake Hofferth asked Ms. Cormello, prior to October the 13th, 2021, and he said this, and they've said this throughout this entire case, prior to the murder of Christina Parcell, which is for you to decide and you to decide alone. Prior to October 13th, 2021, did you have a recommendation as to where Aida Mello should live? In other words, would you have had a recommendation as to whether or not she lived with her mother? And what was Vanessa Cormello's answer to that? And you can hear this for yourself. At the time, I would have recommended the mom. At the time. There was no follow-up to talk about other times. Can you trust that evidence? Very important. That's the circumstantial evidence. Now, let's talk about the direct evidence that you received from Zach himself as to why he did what he did. He got on that stand, he told you. Let's talk about the direct evidence. He talked about what he knew. What he was told by John Mello. That was part of it. He talked about that. But contrary to what Mr. Wilkins said, he had a lot of other information besides just what John Mello told him. He had a deposition that Christina Parcell gave under oath in July of 2016. And you remember I asked him, after you read that deposition, what did you believe about Christina Parcell? What did you believe? He said he believed that she was engaged in prostitution. He said he believed that she had participated in a pornographic movie. He said that he believed that she had used drugs after reading that deposition. Another document that Zach got, Alex Field's affidavit. Now, this is very important to consider about this. This entire case, the state has worked very hard to distance Christina Parcell from the escort website. And they've made these conclusions just because they want to. Despite the fact that there are website addresses on those photographs, they have insisted that those photographs were private photographs, were taken by John Mello and then somehow put on the internet by John Mello, that she had nothing to do with that. Right? Think about this. And this is an evidence for you to consider. The Alex Fields affidavit, it has one page on the front, which is what he said, that they met randomly at Hall's in 2018, that she propositioned him for sex and drugs in exchange for money. He turned that down. But in the second page of the affidavit for Alex Fields, John Mello, in that advertisement, said, if you know this woman, her name is Christina Parcell, and then he puts the Caroline Warren alias in that ad. Right? Here's the question for you to consider. If he didn't think that she really and truly went by Caroline Warren online, why would he put Caroline Warren's name in an ad for people to respond to? Why would he include that if he did not think that may trigger someone who had seen her site? Why would he do that? I would submit to you, he put her name on that ad because she was Caroline Warren, and he was hopeful that someone who had seen the ad or used the ad would recognize the picture and contact him. That's the only reason why that makes sense. Let's talk about the other evidence, and let's talk about the elephant in the room. Let's just talk about that Mr. Wilkins discussed. The planning, right? Let's talk about that. Zach was very honest when he testified about the planning. He told you in detail what he did. In a lot of cases, planning can be good evidence. In a lot of cases. As Mr. Wilkins said, this is a very unique case. And probably one of the most unique aspects about this case is that the person who Zach believed posed the danger was the mother to her own child. Think about that. This isn't where you're home and an intruder comes in, you don't know, and it's a spur of the moment. This isn't a random interaction or difficulty. This is what Zach believed. This is a mother, the person who's charged with caring for your child. Most importantly, the person of all on the whole planet who is supposed to be the most nurturing. This is the person who is doing this to the child. The person who lives with the child, The evidence was the person who shared a room with the child, the person who's with the child all the time. So in a situation like that, where you have a belief that's grounded on documents, that's grounded on information shared with you over many, many months, when you have that belief, how do you alleviate that threat, the threat from the mom, without thinking through how to do it? How do you do that? And so I would submit to you, ladies and gentlemen, that the planning in this case, unlike most any other case, doesn't show malice because the mom was the threat. The mom was the one who posed the danger. Mr. Wilkins talked a lot about, this was just interjecting in the custody, just get John custody, get him custody, all right? If this was all about the custody, why would Zach have waited so long to do it? Right? Part of it, he was in a process. Part of it, he was working on this music project. But the other part is, Aida and John were separated for half a year. Right? If Zach wanted to fix it to solve John's problem, he would have done it much sooner. But the reason why it took so long is that Zach agonized over it. What do I do? Over time, he continued to get information. What do I do? He didn't want to do it. If he wanted to do it, he would have done it right away. And he told you that when he testified. He told you in detail about that day. He told you about it. About when he woke up, he drove to that location and he thought he was going to throw up. He told you about his hand shaking. He told you about when he got out and got on his bike, it was one pedal in front of the other, just trying to make it there. He told you about this. And you saw him testify. He's, contrary to what Mr. Wilkins said, he doesn't think he's a hero. He's never asked that. He did what he believed he had to do to save an innocent child. That's what he did. That's why it's more than just the action. He hasn't confessed to any crime. He told you what he did. And he told you the truth about what he did. If Mr. Wilkins talked about solving John's problem, right? And he intimated in his closing that an aspiring or starving, I can't remember what word he used, pianist would turn down $10,000. Interesting. As though to say he didn't turn it down. There's no evidence anywhere that John Mello ever paid him a dime to do this. None. You've got to watch the state, ladies and gentlemen. Lot of in the state's closing, lot of moral indignation. That, what do you mean try to be humane? Who can say that? How does that even mean, right? I was not in Zach's shoes. Nobody was in Zach's shoes but Zach. Nobody was. None of us has been in a circumstance where we have reason to believe an innocent child is being abused by her own mother, where her father is out of the country, the evidence is shown, with a warrant pending, can't come back. When you write an affidavit to try to put the authorities on notice as to what you believe is happening, when you call DSS and DSS does nothing, none of us have been presented with that circumstance. Mr. Wilkins said, we can't condone vigilante justice. That's what he said. He said, if you find him not guilty, I'm going to be out of a job. Right? It's really interesting. The state wants you to be a legislature and make decisions for the people of the state in law and order. But they don't want you to be a jury when it comes to deciding how the law applies to the facts. Because they just want you to assume he's already confessed to it, he's guilty of a crime. They use the word murder throughout, which is a legal phrase, which is an offense that you have to find. So they want you to speak for the people of the whole state, but they don't want you to really look at the evidence. And that's what we're asking for. That's just what we're asking for. Mr. Wilkins said he could have done other things. This didn't have to happen. Okay? The judge will not instruct you that Zach Hughes had a burden to exhaust all remedies, to try everything he could to do. He tried a lot. He wrote the affidavit, went to DSS, did a lot of different things. But there's absolutely no requirement. We have no burden whatsoever. Just to continue to remind you that. We have no burden whatsoever. The burden is on the state. And there's no burden whatsoever for me as Zach Hughes' representative to try to prove to you that he exhausted every remedy. That's just not what the law says, and you don't need to prove. You don't need to even consider that. The evidence is that Zach tried. And when everything failed, that's when he acted to do what he thought was right, and that is, and was, to save i.e. Mello. Ladies and gentlemen, the state talked about the mailers, and I don't envy your task. I don't at all. It's a tall task. But I do think the mailers, this piece of the case is a little bit easier for you to resolve, and let me tell you why. The judge is going to tell you that for it to be harassment, a couple things have to happen. First, the person who was the target of the harassment, in this case Christina Parcell, who's alleged in the indictment, the state must prove beyond a reasonable doubt that she actually suffered mental distress, and that a reasonable person would have done so in that circumstance. But there has to be evidence that she actually suffered distress, mental distress. There is almost zero evidence that she actually experienced mental distress in this case, right? Let me talk more about that in specifics. There were at least 3 people who testified for the state who were with her when she gave the letters, those envelopes to law enforcement. At least 3 people. Brad Post, Dan Bevel, Mike Nicholson. Did any of those people testify that she was remotely upset? Any of those people say that she cried? Any of those people say that she was shaking? Any of those people say that she had made statements that led them to believe she was upset? Zero evidence that shows, or that even comes close to proving, that Christina Parcell was upset. And if anything, the evidence you've seen that has been introduced with nude photos of Christina Parcell online, with Alex Fields' affidavit, I think the evidence shows took a lot to get her upset or be in mental distress. So I would submit to you, ladies and gentlemen, on the harassment charge, that's something that you could go to initially and think about that evidence. And based on your recollection of the evidence, if you find that there's no evidence to prove beyond a reasonable doubt that she was in mental distress, then that's your answer on that charge right there. It's the state's burden of proof on each and every element. Ladies and gentlemen, in conclusion, the state has brought us here. And they've brought the charges that you are to consider. They've decided what to charge, and they have brought us here on these specific charges. And the charge they brought, specifically the charge of murder, is among the most serious charges there is. Doesn't get any more serious than that. Murder, the charge of murder, in contrast to what the state's position is, requires more than the act of killing another person. It requires malice. Malice is defined, and the judge is going to define this for you, as evil, as hatred. In his opening statement, Mr. Wilkins told you an angry heart, mad. Ladies and gentlemen, I would submit to you that the evidence in this case has failed to show you that you should be firmly convinced that Zach Hughes had hatred. You can be shown pictures and talked all about the acts, but when it comes to what he was thinking, what the evidence shows that was in his heart, that evidence hasn't come close. Ladies and gentlemen, in hindsight, 3 years after this happened, it's very fair for you to say this didn't happen, or this didn't have to happen, or disagree, I wouldn't have done that. Some of you may say you would have, some of you may say you wouldn't. That's fair. Bottom line. Can't say otherwise. But no matter what your take on what he did, I think it's so important that we rely on your common sense. And that was one of the things that Mr. Wilkins talked about early on, that how important your common sense is that you bring with you. And so in closing, I'm going to ask that you use your common sense that you brought with you to the courthouse and just ask yourself, does a person who kills another person with the intent to save an innocent child, does that person have evil in their heart? Does that person have an angry heart? Ladies and gentlemen, I would suggest to you that your common sense would tell you no. And that person who killed another to save an innocent child is not a murderer. I would ask that you return a not guilty verdict. Thank you very much.
Please, the court.
Now the state has an opportunity to rebut, and I promise you, ladies and gentlemen, I'm going to be brief, so y'all can get to your deliberations. I do want to address a couple of issues. I want to make very clear, in this record, there is zero evidence of any kind of abuse. Not for a witness, not from any evidence. Mr. Moorman said you got to have some emotional distress from the harassment charges. Christina Parcell had a bunch of neighbors receive pictures of her without clothes on, private photos between her and John Mello. And so what did she do? Immediately, Brad Post corralled them all up, took some from neighbors so they didn't see them, and she went to the police. Going to the police without emotional distress is not something that you see very often. Mr. Moorman talked about not trying to minimize this case. Minimize the killing of Christina Parcell. Minimizing the heinousness of this crime while trying to impugn her character. He talked about malice, and he said that you got to have an angry heart. He kept referring to me. I said, an angry heart, malice, if you're mad at somebody. And I'll leave you with this. Ladies and gentlemen, in regards to an angry heart, just because Zachary Hughes' heart is so cold and so dead that it can't be angry, that is not a defense. You prove it by his actions. Thank you.
Members of the jury, it is now my duty as the trial judge to instruct you on the law applicable to this case. And in that regard, it is your duty as jurors to accept and apply the law as I now state it to you. Furthermore, it is your exclusive duty to decide all the issues of fact in this case and determine the effect, the value, the weight, and the truth of the evidence. All the parties have the right to expect that you will carefully consider and evaluate the evidence and apply the law of the case to it so that in the end, all parties will receive a fair and an impartial trial. I remind you that during this trial, you and I have certain duties to perform. As the trial judge, it is my responsibility to preside over the trial of this case, and I also have the duty to rule on the admissibility of the evidence offered during this trial. You are to consider only the competent evidence before you. If there was any testimony ordered stricken from the record during this trial, you must disregard that testimony, and furthermore, you should not even mention or discuss any testimony that I've instructed you to disregard in the deliberation room. You are to consider only the testimony which has been presented from this witness stand, any exhibits which have been made a part of the record in this case, and any stipulations of counsel. I have the additional duty to charge you the law applicable to this case. As the presiding judge, I am the sole judge of the law of this case, and it is your duty as jurors to accept and apply the law as I now state it to you. If you already have any idea as to what the law is or what the law ought to be, and it does not agree with what I now tell you the law is, you must abandon this idea because you are sworn to accept the law and apply the law exactly as I state it to you. In every case tried in this court before a jury, the jury becomes the sole and exclusive judge of the facts in a case. A trial judge cannot intimate, state, comment on, or make any statement to a trial jury about the facts in a case. Since you, the jury, are the sole judge of the facts in this case, you are not to infer from what I have said during this process or during the progress of this trial in ruling upon the admissibility of evidence or otherwise, or anything that I say now during this course of this instruction to you, that I have any opinion about the facts in this case. The law does not allow me to have an opinion about the facts in this case. This is a matter solely for you, the jury, to determine. And as jurors, it is your duty to determine the effect, the value, the weight, and the truth of the evidence presented during this trial. The defendant is charged with the following: murder, possession of a weapon during the commission of a violent crime, burglary, first degree, conspiracy, and harassment, first degree. I remind you that the fact the defendant was arrested, charged, and indicted in this case is not evidence in this case and cannot be considered by you as evidence of guilt in this case, nor does it create any presumption or inference of guilt. These documents are simply the formal instruments which contain the charges made against the defendant. It is the formal documents by which this case is brought into this court. The indictments in this case allege several different offenses against the defendant. Each indictment charges a separate and distinct offense, and you must decide each indictment separately on the evidence and the law applicable to it, uninfluenced by your decision as to any other indictment. The defendant may be convicted or acquitted on any or all of the offenses charged. You will be asked to write a separate verdict of guilty or not guilty for each indictment. The defendant has pled not guilty to these indictments, and that plea puts the burden on the state to prove the defendant guilty. A person charged with committing a criminal offense in South Carolina is never required to prove himself innocent. I charge you that it is an important rule of the law that the defendant in a criminal trial, no matter what the seriousness of the charge may be, will always be presumed to be innocent of the crime for which the indictment was issued, unless guilt has been proven by evidence satisfying you of that guilt beyond a reasonable doubt. This presumption of innocence does not end when you begin your deliberations, but it accompanies the defendant throughout the trial until and unless you reach a verdict of guilt based on evidence satisfying you of that guilt beyond a reasonable doubt. The presumption of innocence is not mere legal theory, and it is not just a legal phrase. It is a substantial right to which every defendant is entitled unless you, the jury, are satisfied from the evidence of the defendant's guilt beyond a reasonable doubt. The state has the burden of proving the defendant guilty beyond a reasonable doubt, and some of you may have served as jurors in civil cases where you were told that it is only necessary to prove that a fact is more likely true than not true, such as by the greater weight or preponderance of the evidence. In criminal cases, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. A reasonable doubt is the kind of doubt that would make a reasonable person hesitate to act. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every possible doubt. If, based on your consideration of the evidence, you're firmly convinced that the defendant is guilty of the crime charged, you must find the defendant guilty. If, on the other hand, you think there's a real possibility that the defendant is not guilty, you must give the defendant the benefit of the doubt and find him not guilty. Facts and circumstance that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the accused. Facts in issue may be proved either by direct evidence or indirect evidence or circumstantial evidence. It is direct evidence if it proves a fact without an inference, and which in itself, if true, conclusively establishes that fact. Direct evidence is basically evidence you can see, observe, or hear with your senses. Circumstantial evidence means the proof of a chain of facts and circumstances indicating the existence of a fact. In other words, you may infer that a particular event occurred based on proof of circumstances warranting such an inference. It is not something that one observes, but from facts one can draw a conclusion. Crimes may be proven by circumstantial evidence. The law makes no distinction between the weight or value to be given to either direct or circumstantial evidence. However, to the extent the state relies on circumstantial evidence, all of the circumstances must be consistent with each other, and when taken together, point conclusively to the guilt of the accused beyond a reasonable doubt. If these circumstances merely portray the defendant's behavior as suspicious, the proof has failed. The state has the burden of proving the defendant guilty beyond a reasonable doubt. The burden rests with the state, regardless of whether the state relies on direct evidence, circumstantial evidence, or some combination of the two. The following things are not evidence, and you must not consider them as evidence in deciding the facts of this case. 1, statements and arguments of the attorneys. 2, questions and objections of the attorney. And 3, testimony that I instruct you to disregard. While argument of counsel is a beneficial part of every trial, you should remember that the statements made by counsel are not evidence. In presenting arguments, counsel often refer to evidence. However, you should base your verdict on the evidence as you remember it. Therefore, if there are any conflicts between the recollection of counsel about the evidence and your own recollection, you should rely upon your own understanding of the evidence. Necessarily, you must determine the credibility of witnesses who have testified in this case. Credibility simply means believability. It becomes your duty as jurors to analyze and to evaluate the evidence and determine which evidence convinces you of its truth. In determining the believability of witnesses who have testified in this case, you may believe one witness over several witnesses or several witnesses over one witness. You may believe a part of the testimony of a witness and reject the remaining part of the testimony of that same witness. You may believe the testimony of a witness in its entirety or reject the testimony of a witness in its entirety. You may consider whether any witness has exhibited to you any interest, any bias, prejudice, or other motive in this case. You may also consider the appearance and manner of a witness while on the witness stand. The rules of evidence ordinarily do not permit witnesses to testify to opinions or conclusions, and an exception to this rule exists for witnesses we call expert witnesses. A witness who by education and experience has become expert in some art, science, profession, or calling may state an opinion as to relevant and material matter in which the witness claims to be an expert, and may also state the reasons for the opinion. You should consider any expert opinion received in evidence in this case, and like any other evidence, give it the weight you think it deserves. If you decide that the opinion of an expert witness is not based on sufficient education and experience, or if you conclude that the reasons given in support of the opinion are not sound, or that the opinion is outweighed by other evidence, you may disregard the opinion entirely. An expert witness's testimony is to be given no greater weight than that of other witnesses simply because the witness is an expert. Further, you are not required to accept an expert's opinion, even though it's not contradicted. There's been evidence presented that witnesses have made prior statements which are not consistent with the witness's present testimony. You may use this evidence to decide whether to believe the witness. You may also use evidence of the earlier contradictory statements to determine the truth of those statements. It is up for you to decide whether to believe the earlier statements or the testimony given at trial. If a witness is shown to have knowingly testified untruthfully concerning any material matter, you may consider this in determining whether to trust the witness's testimony as to other matters. You may reject all testimony of that witness or give all or part of the testimony the weight you think it deserves. In order to establish criminal liability, criminal intent is required. For example, the mental state required to be proven by the state for a particular crime might be purpose, intent, knowledge, recklessness, or criminal negligence. Criminal intent must be proven by the state beyond a reasonable doubt, and criminal intent is always a matter that must be determined by the jury from the circumstances surrounding the situation. There's no way to prove intent to a mathematical certainty. There's no way medical science can dissect a person's brain and determine what the person had in mind. So the law says that criminal intent may be inferred from the circumstances shown to have existed. And this is how you make a determination of whether or not the elements requiring intent was present. It is not necessary to establish intent by direct and positive evidence, but intent may be established by inference in the same way as any other fact, by taking into consideration the acts of the parties and all the facts and circumstances of the case. Criminal intent is a mental state, a conscious wrongdoing. It is up to you to determine what the defendant intended to do based on the circumstances shown to have existed. Criminal intent can arise from action or a failure to act. It may arise from negligence, recklessness, or an indifference to duty or to consequences that is considered by the law to be the equivalent of criminal intent. The defendant is charged with murder. The state must prove beyond a reasonable doubt that the defendant killed another person with malice aforethought. Malice is hatred, ill will, or hostility towards another person. It is the intentional doing of a wrongful act and with an intent to inflict an injury or under circumstances that the law will infer an evil intent. Malice aforethought does not require that malice exists for any particular length of time before the act is committed, but malice must exist in the mind of the defendant just before and at the time the act is committed. Therefore, there must be a combination of the previous evil intent and the act. Malice aforethought may be either express or inferred, and these terms express and inferred do not mean different kinds of malice, but merely the manner in which malice may be shown to exist. That is either by direct evidence or by inference from the facts and circumstances which are proved. Express malice is shown when a person speaks words which express hatred or ill will for another, or when the person prepared beforehand to do the act which was later accomplished. For example, any acts of preparation going to show that the deed was within the defendant's mind would be express malice. The defendant is charged with possession of a weapon during the commission of a violent crime, and the state must prove beyond a reasonable doubt that the defendant was in possession of a firearm or knife during the commission of a violent crime. A firearm means any machine gun, automatic rifle, revolver, pistol, or any weapon which is designed to or may be readily converted to expel a projectile. In order to find the defendant guilty of possession of a weapon during the commission of a violent crime, you must first find the defendant guilty of committing a violent crime. Murder is a violent crime. The state must prove beyond a reasonable doubt that the weapon furthered, advanced, or helped in the commission of the crime. The defendant is also charged with first-degree burglary. The state must first prove beyond a reasonable doubt that the defendant entered a dwelling without consent. A dwelling is any building or portion of a building in which a person ordinarily sleeps. A building is a dwelling even if the residents are temporarily absent from the building. In order to prove that the defendant entered the dwelling, the state does not have to show that the defendant's entire body entered the dwelling. The smallest entry is sufficient. It may be any part of the body, such as a hand or foot, or even an instrument, such as a hook or other instrument. In addition, the state does not have to prove that force was used to gain entry. If a person enters a building by using deception, artifice, trick, or misrepresentation to get consent to enter, this is an entry without consent. Next, the state must prove beyond a reasonable doubt that the defendant intended to commit a crime, either a felony or a misdemeanor, at the time of the entry. The mere entry into a dwelling without consent is not burglary. If the intent to commit a crime is formed after the entry, it is not burglary. On the other hand, if the defendant intended to commit a crime at the time of the entry, it is a burglary even if the intent was abandoned after the entry. It does not matter that the intended crime was not completed. Intent may be shown by acts and conduct of the defendant and other circumstances from which you may naturally and reasonably infer intent. Finally, the state must prove beyond a reasonable doubt the existence of one of the following aggravating circumstances, such as 1, when entering while in the dwelling or in immediate flight, the defendant or an accomplice caused physical injury to anyone not participating in the crime, or 2, when entering while in the dwelling or in immediate flight, the defendant or an accomplice used or threatened to use a dangerous object, or 3, when entering while in the dwelling or in immediate flight, the defendant or an accomplice displayed what was or appeared to be a knife, pistol, revolver, rifle, shotgun, machine gun, or other firearm, or 4, when entering while in the dwelling or in the immediate flight, the defendant or an accomplice was armed with a deadly weapon or explosive. A deadly weapon is any article, instrument, or substance which is likely to cause death or great bodily harm, Whether an instrument has been used as a deadly weapon depends on the facts and the circumstances of each case. The following are examples of instruments which may be deadly weapons: a pistol, a shotgun, a rifle, a dirk, a dagger, a knife, a slingshot, metal knuckles, a razor, gasoline, a firebomb, Molotov cocktail, and lighter fluid. A gun may be a deadly weapon, even if it is not operating. The defendant is charged with conspiracy. The state must prove beyond a reasonable doubt that the defendant combined with one or more persons for the purpose of committing an unlawful act or of committing a lawful act by unlawful means. There must be a mutual understanding, agreement, or common intention and plan. Mere passive knowledge of or consent to the criminal conduct of another is not enough to make a person a conspirator. There must be guilty knowledge and participation. Similarly, the mere fact that the defendant may have associated with another person or met with another person and discussed common aims and interests does not necessarily establish proof of the existence of a conspiracy or that the defendant was involved in a conspiracy. On the other hand, it is not necessary that the agreement be a formal one, that it be in writing, that the person hold a meeting and expressly state in the terms of the common plan, or that the agreement be stated in words between them. The agreement of a criminal conspiracy may come into being through an implied mutual understanding. The willful, intentional, and knowing adoption by two or more persons of a common plan is sufficient. No overt acts need to be shown to establish a conspiracy. A conspiracy may be shown by circumstantial evidence and the conduct of the parties. In order to convict the defendant of conspiracy, the state must prove beyond a reasonable doubt not only that the defendant knew of the unlawful conduct, but that the defendant agreed to combine with the other person for the purpose of accomplishing the unlawful conduct. The defendant is charged with harassment first degree. The state must prove beyond a reasonable doubt that the defendant engaged in a pattern of intentional, substantial, and unreasonable intrusion into the private life of a targeted person that served no legitimate purpose and caused the targeted person and would cause a reasonable person in the targeted person's position to suffer mental distress. Intentional means willful, intending the result which actually occurs, not accidentally or involuntary. Intent may be shown by acts and conduct of the defendant and other circumstances from which you may naturally and reasonably infer intent. The state may prove harassment first degree by showing that the defendant engaged in a pattern of 1, following the targeted person as the targeted person moved from location to location; 2, initiating, maintaining, or repeating visual, physical, or verbal contact after the defendant was notified that the contact was unwanted; 3, surveilling or the maintaining a presence near the targeted person's residence, place of work, school, or another place regularly occupied by the targeted person; or 4, committing vandalism and property damage. These are only examples of harassment first degree. You may find that other conduct of the defendant which caused the targeted person mental distress would be harassment first degree. A pattern means 2 or more acts occurring over a period of time, however short, evidencing a continuity of purpose. If you find the defendant not guilty of harassment first degree, you may consider whether the defendant is guilty of harassment second degree. A defendant is guilty of harassment in the second degree if the state proves beyond a reasonable doubt that the defendant engaged in a pattern of intentional, substantial, and unreasonable intrusion into the private life of a targeted person that served no legitimate purpose and caused the targeted person and would cause a reasonable person in the targeted person's position to suffer mental distress. Intentional means willful, intending the result which actually occurs, not accidentally or involuntarily. Intent may be shown by acts and conduct of the defendant and other circumstances from which you may naturally and reasonably infer intent. The state may prove harassment second degree by showing that the defendant engaged in a pattern of verbal, written, or electronic contact that is initiated, maintained, or repeated. These are only examples of harassment second degree. You may find that other conduct of the defendant which caused the targeted person mental distress would be harassment second degree. A pattern means two or more acts occurring over a period of time, however short, evidencing a continuity of purpose. Electronic contact means any transfer of signs, writings, images, sounds, data, intelligence, or information of any nature transmitted in whole or in part by any device, system, or mechanism, including, but not limited to, a wire, radio, computer, electromagnetic, photoelectric, or photo-optical system. In determining the guilt or innocence of the defendant, you cannot consider any possible penalty for any particular crime. The punishment for the crimes is a matter for me to determine and should never be considered by you in any way whatsoever in arriving at an impartial verdict as to the guilt or innocence of the defendant. Madam Foreperson, and ladies and gentlemen of the jury, I wish to express the hope that each of you will be mindful of the importance of your responsibility. You're not called upon to serve as jurors very often, and the proper performance of the duty requires each of you to reach the height of freeing your mind of all improper influences. As the presiding officer of this court, I am vitally concerned that whatever verdict you find will be the result of your going into the jury room and confining your consideration to the evidence and the law that you have heard in this courtroom, weighing it fairly and impartially, as I have every confidence you will do. Your verdict in this case cannot be based on sympathy, compassion, prejudice, or emotion, or some other consideration not found in the evidence. Remember, your verdict must be unanimous. I will now explain the verdict form and possible verdicts. There are 2 pages to the verdict form, and this will go back with you to your jury room. Once you have received that, you'll be instructed at that point to begin deliberation. There are 2 possible verdicts for each charge, which you may find in this case, and there's no significance whatsoever in the order in which I state these possible verdicts. It is simply that one must be stated first. Ladies and gentlemen, your verdict must be a unanimous one. Madam Foreperson, when the jury agrees on the verdict, you will write the verdict on this verdict form and then sign your name as Foreperson. Then knock on the jury room door and inform the bailiff that you have reached a verdict. At that time, we will receive you back into the courtroom. Madam Foreperson, if the jury has any questions, please write the questions on a piece of paper, not the verdict form, and give to the bailiff. Everyone needs to be present when deliberating. If one of you takes a restroom break, then the rest of you should pause deliberations until said person returns. I ask that you now return to your jury room, but do not begin deliberations until you are told by the clerk or the bailiff to do so. There are matters that I must discuss with the attorneys before you begin your deliberations, and if my 4 alternates will remain in the courtroom. Madam Foreperson, I've received a question from you. The question, well, it is define malice, and then the question is malice required for murder charge? And the answer is yes. Please listen as I recharge you on murder. The defendant is charged with murder, and the state must prove beyond a reasonable doubt that the defendant killed another person with malice aforethought. Malice is hatred, ill will, or hostility towards another person. It is the intentional doing of a wrongful act and with an intent to inflict an injury or under circumstances that the law will infer an evil intent. Malice aforethought does not require that malice exists for any particular length of time before the act is committed, but malice must exist in the mind of the defendant just before and at the time the act is committed. Therefore, there must be a combination of the previous evil intent and the act. Malice aforethought may be either expressed or inferred. These terms, express and inferred, do not mean different kinds of malice, but merely the manner in which malice may be shown to exist. That is, either by direct evidence or by inference from the facts and circumstances which are proved. Express malice is shown when a person speaks words which express hatred or ill will for another, or when the person prepared beforehand to do the act which was later accomplished. For example, any acts of preparation going to show that the deed was within the defendant's mind would be express malice. Thank you. You can return to your jury room. You can put that back in there. Okay, ladies and gentlemen, I received your question asking about first and second degree harassment. Harassment first degree. The defendant is charged with harassment first degree. The state must prove beyond a reasonable doubt that the defendant engaged in a pattern of intentional, substantial, and unreasonable intrusion into the private life of a targeted person that served no legitimate purpose and caused the targeted person and would cause a reasonable person in the targeted person's position to suffer mental distress. Intentional means willful, intending the result which actually occurs, not accidentally or involuntary. Intent may be shown by acts and conduct of the defendant and other circumstances from which you may naturally and reasonably infer intent. The state may prove harassment first degree by showing that the defendant engaged in a pattern of 1. Following the targeted person as the targeted person moved from location to location. 2. Initiating, maintaining, or repeating visual, physical, or verbal contact after the defendant was notified that the contact was unwanted. 3. Surveilling or the maintaining a presence near the targeted person's residence, place of work, school, or another place regularly occupied by the targeted person. Or 4. Committing vandalism and property damage. These are only examples of harassment first degree. You may find that other conduct of the defendant which caused the targeted person mental distress would be harassment first degree. A pattern means 2 or more acts occurring over a period of time, however short, evidencing a continuity of purpose. Harassment second degree. If you find the defendant not guilty of harassment first degree, you may consider whether the defendant is guilty of harassment second degree. A defendant is guilty of harassment in the second degree if the state proves beyond a reasonable doubt that the defendant engaged in a pattern of intentional, substantial, and unreasonable intrusion into the private life of a targeted person that served no legitimate purpose and caused the targeted person and would cause a reasonable person in the targeted person's position to suffer mental distress. Intentional means willful, intending the result which actually occurs, not accidentally or involuntarily. Intent may be shown by acts and conduct of the defendant and other circumstances from which you may naturally and reasonably infer intent. The state may prove harassment second degree by showing that the defendant engaged in a pattern of verbal, written, or electronic contact that is initiated, maintained, or repeated. These are only examples of harassment second degree. You may find that other conduct of the defendant which caused the targeted person mental distress would be harassment second degree. A pattern means 2 or more acts occurring over a period of time, however short, evidencing a continuity of purpose. Electronic contact means any transfer of signs, writings, images, sounds, data, intelligence, or information of any nature transmitted in whole or in part by any device, system, or mechanism, including but not limited to a wire, radio, computer, electromagnetic, photoelectric, or photo-optical system. Okay? You may return to your jury room. Madam Foreperson, I've received your question concerning conspiracy and as it pertains to first and second harassment. Conspiracy. The defendant is charged with conspiracy. The state must prove beyond a reasonable doubt that the defendant combined with one or more persons for the purpose of committing an unlawful act or of committing a lawful act by unlawful means. There must be a mutual understanding, agreement, or common intention and plan. Mere passive knowledge of or consent to the criminal conduct of another is not enough to make a person a conspirator. There must be guilty knowledge and participation. Similarly, the mere fact that the defendant may have associated with another person or met with another person and discussed common aims and interests does not necessarily establish proof of the existence of a conspiracy or that the defendant was involved in a conspiracy. On the other hand, it is not necessary that the agreement be a formal one, that it be in writing, that the persons hold a meeting and expressly state the terms of the common plan, or that the agreement be stated in words between them. The agreement of a criminal conspiracy may come into being through an implied mutual understanding. The willful, intentional, and knowing adoption by two or more persons of a common plan is sufficient. No overt acts need to be shown to establish a conspiracy. A conspiracy may be shown by circumstantial evidence and the conduct of the parties. In order to convict the defendant of conspiracy, the state must prove beyond a reasonable doubt not only that the defendant knew of the unlawful conduct, but that the defendant agreed to combine with the other person for the purpose of accomplishing the unlawful conduct. That's the charge on conspiracy, and I would ask you to go back and then look at the verdict form for your direction. Thank you. You can go back, and if you have another question, I'm sorry, I just need to abide by procedure, okay? All right. Hold them for just a second. Before the jury gets in here and the verdict's read, I say this in every trial, that there are a lot of emotions. And I would just ask right now, if you cannot control your emotions, I'm going to give you an opportunity to leave. Otherwise, you're more than welcome to stay. But I just, for everybody involved, please control your emotions, okay? If anybody needs to leave, they can. All right, bring the jury. Madam Foreperson, I understand that you have a verdict.
On behalf,
If you can, please hand it to the bailiff. Madam Clerk, would you please post?
Your Honor, these are case numbers 2024 GS 23-2194, 5425A, 5413, 5412. As to the charge of murder, we, the jury, find the defendant guilty. As to the charge of possession of a weapon during the commission of a violent crime, we, the jury, find the defendant guilty. As to the charge of burglary first degree, we, the jury, find the defendant guilty. As to the charge of harassment first degree, we, the jury, find the defendant not guilty. As to the charge of harassment second degree, we, the jury, find the defendant guilty. As to the charge of conspiracy to commit harassment first degree, we, the jury, find the defendant not guilty. As to the charge of conspiracy to commit harassment second degree, we, the jury, find the defendant guilty. Signed by our foreperson. Ladies and gentlemen, if this is a verdict you reached in your deliberation room and this is still your verdict now, please raise your right hand. Thank you.
Anything from the state? Defense?
Nothing from the state. Nothing as it relates to the jury, Your Honor.
Okay, ladies and gentlemen, I've told you this before, and on behalf of the state of South Carolina and Greenville County, I want to thank you for all of your service for the last 2 weeks. I know this has demanded a lot from you. You all have been extremely attentive. I know that this has not been easy. I'm going to ask you now if you will go back to the jury room, and I will be back there in just a moment to talk to you, okay?
Yes, sir.
Okay. You take your defense.
Your Honor, at this time, I would just make a request that sentencing be deferred to give defense counsel more of an opportunity to present mitigation.
State.
Your Honor, we would oppose that request, and we would ask that you, we proceed to sentencing as soon as possible.
I'm going to give 15 minutes. Fill out them kind of sentencing sheets. Do you feel like you need a little bit more? But I'm going to sentence them within the next 30 minutes.
Thank you, Your Honor. The other thing I would, on behalf of Mr. Hughes, for reasons articulated, specifically that this is probably that the state did not produce sufficient evidence on each and every one of the elements of the offenses for which the jury convicted or on which the jury convicted Mr. Hughes. You, for that reason, would have been for a trial.
Okay. And your motion is denied. You're protected on the record. The only other thing that I need to do is just, and I had discussed this with counsel, as far as the verdict form up at the top, it just needs to be amended to read 2022 GS 23002194, and then it will be 2024 5425A, 2024 5413, and 2024 5412. I just wanted to make sure that that was on the record. It was just just more of a typographical, the 4 instead of the 2.
Yes, sir.
Okay.
Yes, sir. You have no objection.
No objection, Mr. State.
What? And I'll just write on here. Thank you. All right, we'll be back in 30 minutes, 15 minutes.
15 minutes, we got you.
Okay, all right. Council approach, briefly. Okay, I'll hear from the state.
Thank you, Alderman. Please, court. We're prepared for sentencing. That's what we're here for today. You've heard a long 2-week trial. You've heard about the actions of the defendant. You've seen the extreme violence in this particular case. Calculated, the premeditation. The jury's found him guilty. Your Honor, the state would be requesting a life sentence for the murder and for the burglary first charges. But before you switch over to the defense, I have Tina Parcell here who would like to address the court, which is the sister of Christina Parcell.
Okay. Thank you, Ms. Parcell.
Thank you, Your Honor. I will apologize in advance. I didn't expect to actually reach this point today. This is my second victim statement in 24 hours. Yesterday was reliving the 2 worst days of my life, between hearing the step-by-step account of my sister's murder, Mr. Mello's 2 new charges, his bond hearing, and my niece being put into emergency protective care again. So I am exhausted, and I'm going to do my best to express myself appropriately. So with Your Honor's leniency, just give me a bit of grace. My understanding is this conversation is with you. This isn't with the defendant. This is not with counsel. This is not with the gallery. So this is a conversation with you. And I've had 3 years to try to articulate how this has impacted me, and I still have yet to find the words, and it won't happen tonight either. So I've decided instead to talk about what logically should be taken into consideration for any sentencing, which is remorse, rehabilitation, and recidivism. This defendant sat on that stand with full disregard for the authority of the law when it came to his actions outside of this courtroom, in blatant disregard for the authority of law inside this courtroom. He recounted step by step in excruciating detail everything he did. And if I may paraphrase the defense counsel's closing statement, did he cry? Did he shake? Did he look visibly distressed? He said the word repulsed, but did he once look repulsed? He said the word vomited. Did he ever once look nauseated as he described dragging my sister through my living room? Cold doesn't begin to describe the lack of emotion. And if I may be blunt, if we're going to argue somebody has to have malice and hate in their heart to be capable of murder, then one could also argue that anyone medically diagnosed as antisocial personality disorder is therefore not capable of committing murder. I think that is a logical fallacy, is asinine, and the fact that I'm tired, I will no longer go down that, but there has been no remorse once shown by this defendant in this courtroom. Without remorse, you cannot have rehabilitation. Rehabilitation requires acknowledgement that I have done a wrong, I have a debt to pay, and I can improve to become a better member of society. It begins with remorse. Without remorse, there is no rehabilitation. Without remorse, without rehabilitation, you have recidivism. This man, no, I'm sorry, this defendant wanted to kill someone. He joined the Marines, specifically the infantry. He wanted to kill someone. He was given a target on a silver platter. He was given an address, a date, a time, and he planned it. Because he knew that if he planned it just enough, he would never get caught. He planned it so much that he thought, well, even when I got caught, I got this. I can still get out of this. Without remorse, without rehabilitation, any person that goes through that effort to commit a murder would absolutely do it again to see if they could. You're left with either two options. Either he is a weak, easily manipulated man who would kill anybody that anyone asked him to, or he's not a weak and easily manipulated man. And if that's the case, then he absolutely would do this again to see if he's smart enough this time, to see if he can beat it this time, because he has shown no respect for the law of this courtroom. The only thing that I will say about this situation overall is that all of these men did nothing but use my sister. John Mello used her to create a whole new family when he had a wife and children already. Brad Post used her. This defendant used her. All of them used her for their own twisted personal gratification. He would do it again. Without remorse, without rehabilitation, you will have recidivism. Thank you, Your Honor.
Thank you, ma'am. Anybody else from the state? Okay. Defense.
Your Honor, may it please the court, Your Honor's presided over this trial. Your Honor is aware of the evidence that was presented at the trial. Your Honor is also aware of the evidence that was proffered. We do believe that could go to mitigation, so we would ask Your Honor to consider that very carefully. Zach has no prior criminal history, and he stands ready for sentencing. Your Honor, I would ask for Mr. David Hughes, Zach's father, to have the opportunity to address the court briefly.
Just stand right there.
Thank you, Your Honor, for the opportunity to speak a few words on my son's behalf. The trial is over. A verdict's been rendered, and we accept that. What I want to speak to, because I understand this is the sentencing phase of the trial, where you have some parameter of your sentence. My son is probably, in my lifetime, and I've run into some pretty amazing people, and this is going to be seen as a bias from the father, but he has got such a strong moral compass and fortitude and desire for the truth in his life than really anyone I've ever met. He actually eclipses a lot of those things that I aspire to myself. It's what makes his music so incredibly meaningful, because as a musician, and there are some world-class musicians sitting here today, colleagues of Zach's, what makes a musician's art come through is what's the essence of who they are. It's not something you can fake. When you hear it, you know it's a fake. When you hear music that causes people in a room to weep, you know it's coming from something inside that person that you cannot describe. Zach was not born with a silver spoon in his mouth. I want to tell you that. I taught all my children, Zach being the oldest, the value of hard work. He might have been the only person at Juilliard to show up without manicured fingernails and calluses instead. He worked hard. I pushed him hard. Fathers and parents tend to do that with their firstborn child. And maybe I pushed him, a little hard at times, but it made him the man he is today. I want to address something, and Mr. Wilkins,
I gotta just address the whole thing. I'm sorry, just address the whole thing.
that Zach is a cold-blooded killer. I am sorry. Zach wrote his mother and I a letter delivered to us through his attorneys approximately a month ago. In that letter, he described basically what he did in that chair over there, only in a little more detail. Why he did what he had to do, what he felt he had to do. You heard him say in that chair, he wasn't going to go on a cruise ship to Bora Bora, where he was headed, and look at himself in the mirror at night after playing beautiful classical music for rich people. He couldn't do that. Zach has been brutally honest in his life. So much, sometimes to the detriment of his own career. Everybody in the piano world wants to be a soloist with an orchestra. But it's a very small amount of room on the head of that pin, and that's where he was headed. But he had people in his life, donors, rich benefactors, who made demands of him artistically in exchange for their financial benefit, and he walked away from it to the detriment of his own career. Why do I bring that up? He has such a strong moral compass and a desire for the truth that sometimes he actually hurts himself. His friends here, all these people in this courtroom for the last 2 weeks have been here day in, day out, some as far as from Seattle, Washington. They're here because they grew up with Zach in the music world, and they saw something in him they didn't see in anybody else. He has got a loyal circle of friends that I never had. I told my kids when they grew up, if you, at the end of your life, you end up with 2 or 3 people in your hand that are really there for you, that's the guy I want in the foxhole with me. Consider yourself lucky. Zach's got a dozen of those. Why? Bettina, I'm sorry for your loss. I'm not supposed to mention her name. I'm sorry. But I want you to know, Zach had felt compelled to do what he did because of what he would quote Edmund Burke on this. The only thing necessary for evil to prosper is for good men to do nothing. Okay. His desire for the truth and his truthful telling of what happened. I mean, he sat there and he didn't hold anything back that would benefit his portrayal to this court. He's just as brutally honest with himself as he is with other people. He has no criminal record whatsoever before this event. The only thing I know of is an outstanding traffic ticket in Italy somehow he rang up when he was there with Mello. And several of the guards in the detention center, where he's been for 3 years, he's been an exemplary inmate, have told him that they were going to come to this trial to support him. When you gain the silent respect of law enforcement officers, they see something in you, they see it all. And they see a guy that's respectful for 3 years without a single incident. I think that counts for something. So I'm just here, I'll wrap it up. As you determine your sentencing, I would ask you to consider what type of man he is. And take that into consideration. I love my son. I'm proud of my son. Thank you, Your Honor.
Anything else from the state?
No, Your Honor. Your Honor, just for the purpose of the record, I don't, would Your Honor want to inquire Zach as to whether or not he wishes to speak?
That is up to you. Sorry, I thought that you had indicated that you did.
Right, he does not wish to speak. I just want to put that on record.
Okay. Zachary David Hughes, indictment 2022 GS 2302194, indictment for murder. You're to be committed to the State Department of Corrections for life. Indictment 2022 GS 23-02194. You're to be committed to the South Carolina Department of Corrections for 5 years. That is to run concurrent. Indictment 2024 GS 23-05425A for burglary first degree to run concurrent is for you to be committed to the South Carolina Department of Corrections for life. The other two indictments, 2024 GS 23-05413 for conspiracy to commit harassment second degree is 30 days time served. Indictment 2024 GS 23-05412, harassment second degree, 30 days time served. Be dismissed.